1, 2, 3. Go ahead.
Welcome back to class again. We're going to be covering chapter 2 of your textbook, and the topic for today is law and crime. Our learning objectives. Today we will learn about the 4 key elements in defining law. We're going to be able to identify the 3 key characteristics of the common law. We are going to learn about the importance of the adversarial system. You're going to be able to name the 4 amendments of the Bill of Rights that deal specifically with criminal procedure. Next, we're going to be able to list 5 major areas of civil law, list the major elements of crime, identify some of the most important legal defenses in American law. Lastly, we will learn about the effects of criminal law on courts. The basis of American law is the 4 key elements defining law. What is a law? A law is a body of rules. Law is enacted by public officials. Law is enacted in a legitimate manner. And our law is backed by the force of the state, or when it comes to federal law, is backed by the force of the federal government. Common law, heritage. What is the source of our common law? The common law to the entire land. Our common law has its origin to the Anglo-Saxon or Anglo-American law, used by English-speaking people through the world. What I normally ask my class in the past, who are these people we are talking about? Those are the same people that first landed at the coast of American Syria. In other words, we are talking about the British people that sailed towards America, that they describe as the New World. Louisiana, for example, is unique among American states. They use the French system of civil law, but still uses the common law for crime. What is the origin of that French civil law? For some of you that may not know, Louisiana used to be a French colony until it was purchased by United States of America under what is otherwise known as the Louisiana Purchase. That's the reason why they still kept some of the French system of law in their state. And on the same side, they use the same common law for crimes. The 3 common law heritage. When we are talking about heritage, we are talking about the origin. These are the 3 key characteristics of a common law. We have judge-made law. It's based on what? It's based on precedent. In other words, for the first time, or as an example. And then we also have stare decisis. Otherwise known as, it's a Latin word that otherwise known as let the decision stands. We also found our common law in uncodified sources. Common law predominantly judge-made rather than created by legislation. Then we also have the modern criminal law. These are the laws passed by our legislative bodies through enactment of codes. For example, our federal laws are being passed by members of the House of Congress and the Senate of the United States. When it comes to the state law, our state law are being passed by our state legislature. which also includes the House of Representatives at your state level and the senators at also the state level. Let's talk about laws based on precedent. We talk about stare decisis. It translatorally means what? Let the decision stands. It's followed previous court decisions with similar facts of a case. When a court follows previous court decisions, the system promotes fairness and consistency in judicial decision making. It also leads to a cautious approach to problem solving. We also have laws found in multiple sources. Courts must know how the cases were interpreted, as well as their location in the law book. Here are the four main sources of American law. Our first source of law in the United States is the Constitution of the United States. The second, they are known as codes or statutes. Then, we also have administrative rules and regulations. Court opinions or cases, those are known as judge-made law. Let's talk about the Constitution of the United States. It is the base for the fundamental rules which dictate how people will be governed. It creates guidelines or rules for establishing the government. It's also the first document establishing principles and general laws of a nation or a state. It defines the powers each branch of government may exercise. Let's talk about codes or statutes. These are rules enacted by state or federal legislation and are the product of the legislative process or legislative body. In other words, your federal representatives and senators, or at the local level, your local House of Representatives for your state and the senators at your state level. Local government rules are often called municipal ordinances. Let me give you an example of them, of a municipal ordinances. An example of them would be where the city or your city that you live in might tell you you cannot park a non-working car in the front of your house. And even if you do park it there, most cities will tell you you cannot leave it there past 30 days. But you could also park the same car if you have a driveway. You just can't park it on the city street. And if you do, after 30 days, they will tow that car away. Another ordinance from the municipal government or your local city council will be where you cannot put your trash out until the day of the trash, or where you could not have a garage day sales without getting a permit from the city, and they want you to have that garage day sales at certain times of the day, mostly during the weekend. And if you do violate that, the city will end up issuing you a ticket or a fine. Now let's go to administrative rules and regulation. Administrative agencies are created by and get their power to act from the legislature. An example of that would be OSHA, Occupational Safety Hazard Agency. Regulations have the force of law, the same way a legislative statute does, and they are often interpreted by the courts. An example of that you have the Internal Revenue Service, you have your state boards, and you also have your zoning boards at your state or local level. Now let's go down to judge-made law. Appellate courts are still a very important source of American law. They are not making laws, rather, they are finding it. Constitutional law, still an area that is primarily judge-made law. Under our system, we have adversarial system. In other words, you have the prosecutor and the defense attorney going at it against one another in a civilized manner at the trial courts. We have substantive law. Substantive law, these are rules that create legal obligations. An example of a substantive civil law, you have your tort law, contracts, and domestic relations. Under the substantive criminal law, we have robbery, and then we also have burglary. Now, let's go to the procedural law. They establish the methods of enforcing this obligation. Adversarial system. Under our adversarial system, the burden of proof is on the prosecutor for the state to prove guilt beyond a reasonable doubt. We also have in place, under the Constitution, some safeguard against that. We have cross-examination, which is governed by the Sixth Amendment. We have the division of power, presumptions and inferences, sanity and innocence, burdens of proof, production and persuasion. Under our levels of proof, mere suspicion. What do we mean when we say mere suspicion? In other words, a hunch. Reasonable, articulable suspicion means one can articulate reasons for suspicion. For example, we have a case, otherwise known as Terry versus Ohio, that went before the Supreme Court in 1968. It led to the creation of a stop and frisk for law enforcement based on reasonable articulate suspicion, otherwise known as RAS. Brief, limited investigative detentions. It allowed legal to law enforcement personnel if they can articulate the reason for the detention. It's a landmark case under the Fourth Amendment. Level of proof. What do we mean when we say level of proof? In other words, there has to be a probable cause. What do we mean by probable cause? That's a probability that a crime occurred or that a particular person was involved in a crime. We also have preponderance of evidence. This only applies to civil cases only. Proof more likely than not. You only need about 50% of the proof. Then another level of proof is clear and convincing evidence. And the last one is beyond reasonable doubt. In other words, there has to be compelling and convincing evidence to show that that person commits the crime, or the corporation commits a crime. What are the rights of the accused? Under our Constitution, crime prevention must take place without the violation of individual rights and liberties. We have due process of the law. Key example includes what? The following: the right to remain silent, the right to have a trial by a jury, the right to counsel in a criminal proceeding. The Criminal Procedure Amendment. Where do we find this amendment in our Constitution? We have the Fourth Amendment, which has to deal with search and seizure. The Fifth Amendment deals with double jeopardy and self-incrimination. I know for some of you that are watching cases on TV, that have seen a lot of cases on TV, I do believe that you probably have seen somebody on the stand, or a witness on the stand, that will shout out their Fifth Amendment, say, "Oh, I refuse to say the following things because I may incriminate myself," against self-incrimination. Then you also have the Sixth Amendment that deals with speedy, public, and a fair trial. What does the Eighth Amendment deals with? That's the one that deals with excessive bail, fine, cruel and unusual punishment. An example of unusual punishment would be maybe somebody shoplifted a gown at Walmart that cost $50. And that individual goes before a judge, and the judge is saying, "Well, I'm going to set your bail at $10,000. That would be considered an excessive bail, mostly for crimes like that, unless if that person is an habitual shoplifter. If it's a first-time offender, the bail by no means should be no more than $200. And then you also, maybe after that person was convicted of the crime and the judge was trying to sentence the individual to a term of imprisonment, and the judge decided to say, "Oh, well, even though what you stole was $50, I'm going to sentence you to 10 years in prison." That would be considered unusual punishment under our Constitution. Now let's go down to types of civil cases. We have tort law that deals with legal wrongs to another. We have contracts law, property law, domestic relations law, inheritance law. Under the legal wrong to one another, you could have, an example of that would be when you have an individual, maybe they were involved in an accident with another person, and that person didn't have insurance, and they promised to fix the other person's car, and they refused to fix that car. So the injured person can go to court to file charges under a civil dispute. You also have the contract, which deals with businesses, where individuals agree to perform in return for monetary compensation. You also have the property, under the property laws that deals with our houses, real estates. We also have domestic relations. When we talk about domestic relations, the most popular thing among them is when the husband and wife are trying to divorce one another, and they go before the court to file the paperwork for the divorce. Then you also have inheritance. Inheritance has to do with when an individual dies, what is left behind for their children. There may be some dispute where some one of the kids or the adult child might be saying that he or she deserves more than this and that. And they go, he or she file some civil suit in the court. So the inheritance can be distributed evenly. Civil remedy. A remedy, the result, a plaintiff in a case seeking in a civil lawsuit. When we're talking about a plaintiff in a case, that's the person that filed the case in the beginning. And the other person is the defendant in the case. Remedies might be in form of money, damages, a declaratory judgment, or an injunction. Civil remedies for fighting crime. Under civil remedies for fighting crime, we have lawsuit against criminal defendants in order to recover lost property. The court can always award compensation or can award compensation for injuries to person or property. Then we also have declaratory judgment, asset forfeiture. Well, the most common thing going on now is, for some of you that is not familiar with asset forfeiture normally they happen a lot under federal law. For example, you have a guy that's been dealing drug as a drug kingpin, maybe in Dallas area, and he's been using the money receiving from drug to do businesses by buying buildings, shopping centers. In other words, laundering those money to make it a clean money. And when he got caught by the federal government, the government went to court against the individual. And after receiving a judgment of guilty, the U.S. Attorney's Office will seek an asset forfeiture against the individual through the court system. In other words, they will take everything that was ill-gotten as a result of that drug business that the individual was doing. We also deal with injunction. Injunction would be more like a temporary order issued by a judge to stop something from happening or stop somebody from doing something. Let's go to types of injunctions. We have one called temporary restraining order. A temporary injunction could only last a few days that orders a party to refrain from taking certain action until a hearing can be held, such as not taking a child out of a jurisdiction until a custody hearing can be held. That's an example. Then we also have another one called PI, which is the preliminary injunction. It's an injunction issued during the pendency of a civil or a criminal case that orders the parties from taking a certain action in order to maintain the status quo until there is a final judgment in the case, such as ordering a city not to enforce a local ordinance until its constitutionality can be determined. Then let's go down to the last one, permanent injunction. This is an injunction entered as part of a final judgment ordering a party to refrain from or to perform certain actions, such as ordering a company to permanently stop dumping industrial waste into a river. Those are the three types of injunction. Criminal law overview. Under our criminal law, we have misdemeanor. Those are less serious crimes punishable by a fine and less than a year in jail. The next one is a felony. Depending upon the state that you live in, it is typically defined by the term or location of imprisonment. In Texas, anything over 1 year in prison. Then that person goes to a state prison or a county jail. Okay, let's look at the differences between civil and criminal law. Under our civil law, who is the party in a civil law? You have the plaintiff. That's the person that filed the charges. Then you have the defending party, which is the defendant. In a criminal law, who filed the charges? The state filed the charges. And if it's a federal law, who will file the charges? The U.S. Attorney's Office will file the charges. And the defendant will also be the person that commits the crime in a criminal law. What are the burden of persuasion under the civil law? In the civil law, it is known as the preponderance of evidence. In the criminal law, it is beyond reasonable doubt in order to find that person guilty or not guilty. Jury verdict. Under the civil law, less than unanimous in many states. In the criminal law, it has to be unanimous. In other words, in the criminal trial, all the jurors have to agree. What are the remedies in a civil law? Mostly monetary damages. In a criminal law, someone can be fined and sent to prison or probation, or with what we know as intermediate sanction. Defendant's testimony in a civil law may be forced to testify in a civil law. In a criminal law, you remember I talked to you about the Fifth Amendment. Constitutional right to remain silent. You could plead your Fifth Amendment, the right to self-incrimination. The right to counsel under civil law, no constitutional right to a counsel. You have no right to be accorded a lawyer.